Is Marion Gager present? Marion Gager is not present. Did someone check in for that name?
No.
So he's not here, neither is he.
Oh, someone trying to get in.
He's trying to log in right now.
Who's speaking?
Dea.
Do you have a full name?
Dea Dennis.
I can't see you. Why is it dark? Letitia Clinton, start your video. On the record in the matter of the people of the state of Michigan versus Kamarion Kajar 24-03636. Raya Parker 24-03638. Dea Dennis file number 24-03639, and Letitia Clinton 24-03637. Council appearances, please.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Luke Goodrich from the Public Defender's Office, here to represent Ms. Parker, who's appearing over Zoom this morning.
Your Honor, my name is Keith Watson. I'm the public defender. I appear on behalf of the Office of the Public Defender. Letitia Clinton appears remotely via Zoom. I was just on the telephone with her, recognizing that now that she appears via Zoom. Your Honor, this being a 4 co-defendant case, it was quite difficult for us to secure.
I'm not finished with all the appearances yet, though.
Oh, I'm sorry.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Dea Dennis. We are both present via Zoom.
So I don't have Marion Kajar present, nor do I have his attorney.
Kamarion is here, man.
Okay, what is your name, sir?
Kamarion Kedgar.
Okay, you can take your hood off.
Okay.
Okay, I don't know where his attorney is, however. Okay, counsel, you wanted to make a record of something?
Yes, Your Honor. Good morning. Again, my name is Keith Watson. I'm the public defender. Letitia Clinton is one of 4 co-defendants in this case. And our office represents one of these co-defendants, Mr. Goodrich, here on behalf of that co-defendant. As a result, Your Honor, we were obligated to find conflict roster attorneys to be accepting of these cases. I had quite a difficult time finding a 4th or 3rd conflict roster attorney. I've now secured one. David Carter, he is presently not willing to take the case. We would request that if Your Honor were to find good cause, that Your Honor might allow the examination to take place as soon as the 9th of January. I'm very sorry, Your Honor. I have to tell you is that I did my very best. My assistant, my administrator, and I have all made efforts, not just inside of this county, but in all of the surrounding counties, even those who are not ordinarily on our roster, but who might accept cases. We squawked out a broken arrow, so to speak. And I was able to get Mr. Carter to take down the case. Ms. Clinton, I would ask that Your Honor might find good cause to allow Mr. Carter to be prepared and to appear. It's not yet filed.
I'll note that in the file. Okay, and then Mr. Goodrich is going to proceed on behalf of Parker.
Yes, sir.
Oh. And so everyone is represented. Well, because I don't know where Mr. Johnson is today, but he was appointed to represent the case.
Excuse me, I'll be pleased to try to get a hold of Mr. Johnson.
Thank you.
We would have assigned him.
Thank you. I believe he filed an appearance. He did not, okay.
My system, but he appeared last week.
I guess we'll wait for him to come back. That before we move forward with addressing the timeline on this. So I'll go off the record on these for now. On the record in the matter of the people of the state of Michigan versus Jeffrey Lynn Clark 24-03661, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Your Honor, we're gonna get to watch it from the state.
Is Mr. Clark present?
He's not doing that.
My understanding, at least the last information I had noted in the last time I touched this file, was that he was a cardiac patient at Sparrow. However, he failed to appear last week for his probable cause conference, which was held before Judge Ward in my absence. And he's failed to appear today. The court will issue a bench warrant bond forfeiture. You've not had any communication with him?
I have not, Your Honor. The phone number that Mr. Clark gave to the office when I called that number, it belonged to someone, to someone who knows him and who said that she was going to give him the information to contact us. It is my understanding that he's homeless, that he's unhoused.
Trouble issue. We're all set on that matter. Okay, back on the record. Mr. Johnson has just logged in. You know, Mr. Watson went. Step outside and turn your phone off, please. Back on the record in the matter of the state of Michigan versus Kajar, Clinton, Dennis, and Parker. I do see Mr. Johnson present. Have your appearance for the record, please. Mr. Johnson, I need your appearance.
Kareem Johnson on behalf of Mr. Kajar.
Okay, so today was the date that was originally scheduled for a preliminary examination. I do have a note here stating that we were going to treat this as another probable cause conference due to the lack of one of the individuals needing conflict counsel. Mr. Watson has made a record. Conflict counsel has been located by way of Mr. Carter, and he will not be able to appear today, but will be able to take over the case and get caught up. So we're just looking to find good cause on the timeline today because of that, and then get new dates for an exam. Is that accurate? Counsel?
Yes, Your Honor, that's my understanding.
Okay.
Yes, Your Honor.
And so, thank you. So due to the nature of this being a co-defendant matter, and in the interest of judicial economy, wanting to run these together, the court is going to find good cause on each of these matters because of the fact that Ms. Clinton needed to have conflict counsel, and it took some time to get that appointed. And I'll go beyond the 21-day timeline and have this matter reset for a exam for each of them. How long do we anticipate this exam to be? Couple hours, full day?
I don't know if it would be a full day, Your Honor. I'm thinking probably safely say a half day. Just, it might end up being less than that, but I want to err on the side of caution. I expect probably somewhere between 4 and 5 witnesses.
February 20th at 9:30. February 20th at 9:30.
Yes, Your Honor.
In person at the court, any additional matters for the record on, as it relates to the date?
Nothing from Ms. Parker.
Your Honor, I'll inform Mr. Carter and he'll make his appearance. This is for, he is to appear February 20th, 20 at 9:30 in the morning. And Ms. Clinton appears to enroll now. And I believe Your Honor has indicated that she is to appear in person on that day and time before Your Honor. Thank you.
Thank you. Each defendant is to appear in person on the date of February 20th at 9 or before 9:30 for their case to proceed to exam. Mr. Kajar has a bond 5,000, 10% that will continue. There's a no contact order that will continue, and a curfew, 10 p.m. curfew unless with a parent or guardian, and you must attend school. Do you have any questions about your bond, Mr. Kajar? You're muted.
No, ma'am.
Bond will continue. And Mr. Johnson, I don't know that we have an appearance from you on this matter.
Should have been a substitution filed. If not, I can file one with the court today, Your Honor.
Okay, thank you. If you can file that, then I can sign it and we can get the file updated.
Thank you.
Okay. And then Letitia Clinton has a bond 3,500 personal recognizance. There's a no contact order. You're not to be within 2,000 feet of wherever the alleged victim is. That bond will continue. Any additional matters on her for today?
Not on behalf of this.
Bond for Pariah Parker was 3,500 personal recognizance and no contact order not to be within 2,000 feet of wherever the protected party is. That bond will continue. And we'll see her on February 20th at 9:30. Any additional matters on her file?
No, Your Honor.
And lastly, Dear Dennis, that bond was set at 3,500, 10%. A no contact order in place for the protection of the alleged victim and not to be within 2,000 feet of wherever the victim is. That bond will continue. Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor.
Okay, you're all set for today.
Thank you very much.
Thank you.
Thank you, Your Honor.
Stick with it.
Okay. On the record in the matter of the people of the state of Michigan versus Edward McCall, 24-03-139, council appearance.
Good morning, Your Honor. Case Mark Aaron, appearing on behalf of this.
Good morning, Your Honor. Michael Anderson on behalf of Edward Cole, who does appear personally and to my right.
It was the date that was set for a preliminary examination on criminal sexual conduct in the 4th degree. I have a note that there was a request to adjourn. that correct?
I believe there's going to be an adjournment request, Your Honor. However, it would be my position to at least start to preserve the victim testimony on this matter pursuant to MCL 7664. Victim is present. She is here. She's been here twice now. I would hate to drag her down here again just for something that may end up getting waived or put out or ran at a later date. One issue is though, and I certainly understand Mr. Anderson's position, we communicated well. My Detective Kasha Osborne is still out, I assume on medical leave because I haven't heard back from her. She got a surgery in the middle of December. It seemed to be a pretty serious one, so I don't have Detective Osborne here. And I would be requesting to continue to present her testimony as well. However, there also seems to, in light of Detective Osborne being out on medical leave, I tried to follow up on a recorded version, an actual video of the victim's statement that was given to police in this case. We do have the transcribed copy in the report, but we don't have the video yet. And I certainly understand Mr. Anderson's position that videos offer a lot more evidentiary value than a police report. Regardless of that, Your Honor, victim's already been here twice, so I would still be requesting to at least put the victim on the stand, be subject to cross-examination, then continue the exam for Kasha Osborne.
Thank you, Your Honor. I'd just like to, I suppose, add some clarity and definition of what Mr. Martin said. He said there was a transcript, or it was transcribed, the victim's statement. That's not necessarily accurate. There is a summation of what she said. However, especially if Mr. Martin would like to put the victim on the stand, I would like that video, which I've been requesting since we were put on this case, in order to more effectively cross-examine her. Words in fact summation, not actually what was said. In addition, we did receive an incident report involving a statement of my client. I have also requested the video on that, and not received it. As such, in order to be fully prepared for an examination, especially where the detective is not available, I would be asking for an adjournment. This matter. Understand that the named victim, this is the second time for hearing, but the defense does not have all the information necessary in order to proceed with a preliminary examination, despite the requests of the defense.
It's also despite our request to Your Honor. I've tried to reach out to Detective Osborne. I've tried to have our discovery unit reach out to LPD to get these videos. My assumption, although it's not safe to assume in this line of work, is that because Kasha or Detective Osborne was going on medical leave, she probably didn't upload it before she left, and she hasn't been back to the office since. And I certainly understand the defense's concerns. I just wanted to request, because the victim has been down here twice.
I'm going to proceed with the victim's testimony today. That we don't have to resubpoena the victim here, and then it'll be continued. That'll allow you opportunity to get the outstanding discovery, and if you need to resubpoena her, that's fine. But she's here today. We'll proceed today.
Yes, Your Honor. People would call Miracle Haynes. Your Honor, can I have a brief moment?
Sure. Off the record. Okay, there's a microphone that's in front of you. That microphone is so that the lady behind you, the court reporter, can hear everything that's being stated here today. It does not amplify your voice for me, so I need your voice to be loud and clear. I need your responses to be yes and no, not mm-hms, uh-huhs, and not head nods, okay?
Yeah.
Is that a yes?
Yeah.
Okay, if there is a concern about whether or not your answer is yes or no, that's what you'll hear one of us ask you. Is that a yes or a no? And that's because the record has to be clear when she makes a written record of what's being stated here and here so that we know what your original answer is supposed to be. If there's an objection from either attorney, you will stop speaking immediately because I would need to make a ruling on that objection. And then I will have to let you know if you can give us that answer or not, okay?
Okay.
Okay, first state your first and your last name and then spell both.
All right, so my name is Miracle Hayes. My first name is spelled MYRACLE. Last name is spelled HAYES.
Proceed, counsel.
Thank you, Your Honor. Good morning, Miracle. Thank you for being here with us again today. Appreciate you coming down. I just wanted to ask you a few questions, okay? I'm going to take you back to the date of January 5th, 2024. Do you remember that date?
Yes.
Why do you remember that date?
What's your question?
Why do you remember that date? Did something happen?
Yes. I remember that day because that was the day I was inappropriately touched, and it was an impactful day for me.
Now, we'll get into the nitty gritty of all that in a sec. Let's just back up and identify some things first, okay? Are you familiar with the location of 4725 South Cedar Street?
Yes.
What's at that location?
AutoZone.
Were you at that location on the date of January 5th, 2024?
Yes.
Why were you there?
I was there at AutoZone to get my engine light read and help with putting my coolant to my car.
Is this AutoZone, is it located in the city of Lansing?
Yes, it is.
Is that in Ingham County in the state of Michigan?
Yes, it is.
Do you recognize anyone in the courtroom with us here today?
The offender.
You recognize someone in the courtroom?
Yes.
You've identified them as the offender. Do you happen to know their name?
Ted.
Ted?
Edward.
Edward, okay. You know his last name?
McCall.
Edward McCall, full name?
Yes.
That person that you've name identified as Edward McCall, how do you know them?
I know them through AutoZone.
Through this incident?
Yes, I know them through this incident.
That person that you've identified as Edward McCall, could you please just point him out and identify him by an article of clothing he's wearing? What kind of clothes is he
A
wearing?
coat.
For the record, Your Honor, she gestured with her finger
But he's
towards the
wearing a
last
coat
two.
and a tie.
Any objections to identification?
For purposes of examination.
Identification is noted.
Thank you, Your Honor. All right, now let's talk a little bit about this incident at AutoZone. Just whatever you're able to tell me about what you remember. Go ahead, sir.
I remember going in there.
It calls for narrative.
I agree.
I'll rephrase.
Objection sustained.
Let's start with where you were just getting at. What happened when you went to AutoZone, when you first got it?
When I first went inside of AutoZone.
Just walk me through it. What happened?
So when I went inside AutoZone, I stated that I needed help with getting my engine light read, having coolant put in my car. I went inside of AutoZone with my coolant and my funnel in my hand. And like I said, I stated that I need help, in which the offender proceeded to, I guess, assist me.
Let me ask you this, how many employees could you see or were present at this auto zone when you asked for help? Let me phrase it this way, was there other employees around?
No,
No, so it was just the defendant.
yes,
So when you came in, you approached and the defendant offered you help, is that fair?
yes.
What happens after that?
After that point, the offender followed me out to my car where I unlocked my car so that he could pop the hood of my car. And then he opened the hood. He opened the coolant lid for me. I poured the coolant lid or the coolant in. That was done, put the lid on.
At some point, did he physically touch you?
Yes.
Let's talk about that. Let's focus in on that. When did he get physical with you?
So he got physical with me after I went back to my car to move my seat back so that he could have room to do what he needed to do to check the engine light.
Did he ask you to move your seat back?
No, he did not. So I moved my seat back. He stated that he needed my keys. Gave him my keys. At that point, I was kind of standing back from my car to allow him to insert my keys, hook up the engine light reader. He stood back up. He asked me if the odometer meter was on. I said, "What is that?" He said, "What shows the miles?" I could visibly see that the odometer meter was lit up. So I said, "It is on."
Look, Your Honor, at this point,
Thank you.
Okay.
yes, Your Honor, I'll try to break it up a little more.
Well, we just need to get to the actual crime.
Yes, Your Honor, that's what I'm trying to get to. I think it, yes, sir. So I know you were getting there. Let's talk about this. So he asked you to check the odometer meter. Was your car on at this point?
Like starting? No.
Where were you standing at when this happened?
When you asked me when the odometer meter was on, I was standing outside of the car, towards the back of the car.
At some point, did you check the odometer meter based on what he told you?
Yes, I did.
How did you go about checking it?
I stepped up to show him, to point out to him that the odometer meter was in fact lit up and visible. And that's when I felt his hand broke on my left butt cheek.
So when you pointed this out to him, were you standing up straight? Were you bent over?
I was kind of bent like that, pointing and inward to my car, because I had not went like all the way in my car. I didn't sit in my car. I just stepped up to point out that the light was in fact visible.
Was anyone else around you too when this was happening?
Not that I seen. No.
So how soon after you kind of bent over and pointed out the odometer meter was it that you felt his hand on your left butt?
immediately, right after this happening.
Would it be fair to say that it was almost as soon as you bent over?
Yes,
How did you react to the defendant's hand being on your left butt cheek?
I sat back and I slapped the offender. And I said, don't ever do that to me.
Did you ask for him to do this to you?
No, I did not.
Did you give any sort of an indication that you wanted this to happen to you?
No, I did not.
How did he react to being slapped?
He said, I'm sorry.
That it?
Yeah, he just stood there.
And then what happened?
I
Did he say anything else to you about wanting to take you out or any sort of, anything like that?
no.
So just the I'm sorry and then that was it.
He said, I'm sorry. I unplugged the engine light reader. I handed it to him and I said, you can go now. He proceeded to go and back inside of the store.
Did you at some point speak with police about this incident?
Yeah,
Do you recall the officer you spoke to or not?
Osborne.
Do you recall speaking to a detective?
Yes.
Do you remember that detective's name?
Yes,
Osborne?
yes,
Kasha Osborne?
yes,
Would what you told police and Kasha Osborne be similar to what you testified to here in court today?
yes.
Thank you, Your Honor. I have no further questions for this witness.
Prosecutor.
Thank you, Ms. Hayes. I just have a couple questions for you, just some basic ground rules. If you don't understand a question, just let me know. I can repeat it. I'm not trying to trick you. We're just trying to figure out any information today, okay? And if you don't hear me, I know we're kind of close, but just let me know and I can repeat the question, okay? Ms. Hayes, you said that this incident occurred at AutoZone on January 5th. Is that correct?
Yes.
Okay.
January 5th, 2024,
And that was at approximately, it looks like 4:40 in the afternoon,
4:45.
4:45. Okay. And you didn't immediately report this to police, correct?
What do you mean? I'm not understanding.
You, in fact, you called police the next day, is that correct?
I called police the next day.
And you certainly didn't call the police while you were at AutoZone, true?
I did not call the police while I was at AutoZone.
Okay. And Ms. Hayes, did you report what you say Mr. McColl did to anyone at AutoZone that day?
Yes, I did report.
Okay. And did you do that immediately?
Yes,
Do you recall the individual, the name that you did that?
I did not recall the name. I do know the description.
Okay, can you describe that individual?
Yep, African American male with dreads.
And was that done immediately?
Can you ask the question again?
I'm sure. Was that report done immediately
What report?
to the African American male with dreads?
Yes,
And you testified earlier that there was no one else at the AutoZone, true?
no, I didn't say there was no one else. I said that I didn't see anyone else when I went.
Okay, and when you went into the AutoZone, did you walk up to the service desk?
Yes.
And Mr. McColl was the only one there?
Yes,
And can you describe the parking lot of the AutoZone?
ask your question a different way.
where is this AutoZone located?
AutoZone is located on Cedar Street in Lansing, Michigan.
Okay, and there are other businesses around this AutoZone, true?
Yes,
Okay, and you said it's on Cedar Street, correct?
yes,
And this is a fairly busy road, true?
yes,
And you said this was at 440. It was still light at that time, true?
yes.
Okay, and that AutoZone had lights, true?
What?
Had parking lot lights, true?
Parking, I'm not sure what you're asking.
Street lights.
Ask your question again.
Sure. This AutoZone parking lot had street lights, true?
Honestly, I don't know.
But in any event, you said it was light out at that time, correct?
Yeah,
And you recall what day of the week this was?
have a day in mind, but I did not look at the day it was last year. So I would say no, because I don't know give a thought.
I understand, and that's perfectly acceptable. Do you recall if it was a weekday or a weekend?
A weekday.
It was a weekday. And you said you only saw one other, well, when you initially walked in, you only saw Mr. McCall, is that correct?
Yes.
Okay. When you went to report and saw this African American male with dreads, did you see any other AutoZone employees?
No.
Okay.
Not that I remember. There may have been some others, but there may have been. I think there was, but I do recall talking to the man with the dread.
Okay.
I want to say yes, there was some other companies, but
So there may have been other
there may have been,
employees,
yeah.
and there may have been other customers, true?
Not that I know of.
And where did you say your vehicle was located?
I believe the second parking space in front of the AutoZone building.
Okay, and was that right next to the building?
Right in front of the building.
Right in front of the building, and the waiting area to that building, is that glass?
There are glass windows. In the wall, yes.
And those glass windows would have shown your vehicle, correct?
Yes.
And do you know if that AutoZone has any security camera?
I've seen one. Apparently, there hasn't been able to be a video, but I did see one. There is one.
Okay, so that AutoZone has security camera, correct? And did you happen to get the name of the individual that you reported to?
No.
Did you ever follow up with AutoZone?
Yeah, their manager. I talked to their manager.
Do you know their manager's name?
I believe Alex.
And let's get into what you say, Mr. McCall. You testified that Mr. McCall placed his hand on your left buttocks. Is that correct?
Yeah,
Do you know what hand he used?
no,
Did you in fact see him do this?
I did not see him, I felt him.
And can you describe exactly what he did?
He broke his hand on my left buttock.
Okay, did he just place it there?
He broke and he squeezed it, he placed squeeze.
Did you make any noise once he did this?
No,
Did you scream?
no,
You just struck him in the face?
yes,
Was that with an opener or closed fist?
okay.
Would you say that made a noise?
Ask your question again?
Sure. When you smacked him in the face with a open hand, did that make a noise? No, it was silent.
Know how much, what noise you, I mean, other than a hit noise, I don't
Okay,
know.
so a smacking noise.
A smack, yes,
Okay. And you said this was outside in the second parking space, is that correct?
yeah,
And does that parking space face the roadway? Where is it located?
it faces the direction of the AutoZone store,
And again, you said that there were glass windows, correct?
yeah,
Which would have shown that, correct?
showing what,
Shown your vehicle.
yes,
And no, nobody immediately approached you afterwards, correct?
no,
Okay. In fact, you had to go find somebody, correct?
that is correct, yes,
And nobody approached you from any of the other businesses, true?
ask the question again.
Nobody, well, you said there were other businesses around, correct?
There are other businesses on
Okay.
the street of Cedar.
Correct. And nobody approached you from.
Nobody from the other businesses on Cedar Street approached me.
In fact, you don't know if anybody saw this incident, true?
That is correct.
You said you met with a police officer, correct?
Yeah, discussion. with them.
Okay, was that in person or via phone?
Oh,
You met with any police officers as a result of this incident?
I've had communication and we, however, I mean, the last, maybe last almost year. But not that, most of my, communication has been via phone.
All right, you said most. Have you ever met with an officer in person?
No,
At one time, did Mr. McCall get in your vehicle?
yes, well, he, after I handed him my keys, that's when he approached me in my vehicle.
prior to what you said was a grope, did he make any statements to you?
No.
And when you smacked Mr. McCall in the face, well, I'm sorry, did Mr. McCall have glasses on at that time?
Yes.
Okay, when you smacked him in the face, did those glasses fall off?
Yes.
Did they break? Were there any marks left on them?
I don't know.
Were there any marks left on Mr. McCall's face?
I don't know.
Were you wearing any rings at the time?
No,
How long are your rings?
not that long.
How long were they at the time?
They're probably short. I don't know.
And you don't know if it left any marks on Mr. McCall?
No, I don't.
Did you have any contact with Mr. McCall after this?
No.
Just other than the African-American male with dreads, and you said the manager, Alex, have you spoken with anyone else about this incident?
Person.
Anyone else?
My loved one.
Thank you.
Would you reckon?
Yes, sure. Thank you. A lot of questions about other employees on a cross-examination there. Do you work for AutoZone?
No,
Do you know who any of these employees are?
no,
Do you have any way of knowing what they could or could not see? Objections, leading,
no,
or suggesting.
I would agree. Yeah, he's asking, did you know anybody at AutoZone? What was your other question?
I asked, do you have any way of knowing what they could or could not see?
The objections are moved.
Do you have any way of knowing what these people could or could not see?
no,
Do you have any way of knowing what they could or could not hear?
no,
Do you know if the secure surveillance cameras at AutoZone even work?
no,
When you parked your car and this individual came out, was your hood open?
no,
Did he open it?
yes,
Was your door open?
no.
Did he open your door?
What?
Did he open your door or did you? Okay, so when he actually groped you, was your hood and door both open?
My hood was closed, my door was open.
Is it possible from your vantage point that anyone else from inside that store could have seen what happened? Objection, speculation.
There's an objection. That's the speculation.
I don't think he's speculating. This would be based on rationally based perceptions. He was there. In fairness to me, there was a lot of questions on cross asked about what could or could not have been seen from the windows from what sounded like an inside vantage.
You're asking her, is it possible if someone else could have seen?
I can rephrase, but essentially what I'm getting at is, did the door obstruct vision from inside the store?
That's probably a better way to ask it.
Yes, sir. I'll rephrase.
Thank you.
With your car door being open, okay, so you were there and this all happened. With your car door being open,
Is it possible that that obstructed someone's view from inside the store or anyone else's view? Objection, speculation, foundation.
What response would you?
Your Honor, this is the exact same objection, just got overruled. It's being re-raised again. Nothing has changed. I just rephrased the question to exactly what Your Honor said would not be speculative.
What is the foundational?
Foundation is, Mr. Markinen asked if it would have obscured the vision from inside the office. There's been nothing laid that this witness was inside, looked out, and would be able to tell. So objection is the foundation. It is the speculation and personal.
Respond.
Once again, Your Honor, this is based on the witness's rationally based perceptions. She was there, she could see, she could perceive, she could tell whether or not a car door frankly blocking someone's vision is rather common sense.
I don't know if she could tell if, I don't know how it's positioned, but if she's from the outside, if she could tell if someone on the inside could see what's going on the outside.
Yes, Your Honor.
From where she was. Aside of that, she couldn't even tell us if she saw anybody else when she was in the store. So I'm not gonna have her opine on whether or not someone else who may or may not have been in there could have seen. The court can determine that. If her door was open, it's likely it could have obstructed, it's likely it couldn't. We're not there, I'm not sure. So that would cause, it's either way, it sounds like it would create a question of fact anyway. So I'm gonna sustain his objection.
Was your car door open?
Yes.
Where was the defendant when your car door was open? Where was he when he groped you? Do you know?
On the left back side of me.
Inside, outside your car door? Which one?
Outside my car.
So when you say outside of your car door, do you just mean outside of your car? Or do you
Outside.
mean completely past your car door?
Outside of my car.
Where was the car door in relation to the defendant when he groped you? Objection, Your Honor. I think the testimony at this point has been that her back was turned. She understood that the defendant was behind her, but that was it. She could not tell exactly where he was. So my objection is based on personal knowledge and foundation.
There's an objection, so I said when there's an objection, you'd be quiet. Repeat what you were saying.
Objection is a foundation of personal knowledge.
Do you want to respond?
Yes, Your Honor. I think we have the foundation here for the positioning of the people in relation to each other. I understand that we've had testimony that this came from behind her, but it would be within her rationally based perceptions. As she just identified, it was from her left back side, and it also grabbed her left buttocks. I can lay a little more foundation if Your Honor would like, but it seems like she could testify to the positioning of the people at this time based on her rationally based perceptions.
She's already testified she didn't know where he was, or she couldn't see behind her, but your question again was what?
My question just now was where the car door was in relation to the defendant when he groped her. She just testified that she did know where he was and that he was on her left
You want to know
backside.
where the car door was in relation to where he was?
Yes, sir.
Objections over there.
Where was the car door in relation to the defendant at this time?
In front.
What do you mean by in front?
I'm not able to visibly see the car door open.
So are you saying he was behind your car door or was he outside of it?
Behind.
Okay, so he was behind your car door.
Yes.
Was this when he groped you?
Yes.
How did he react after you slapped him? What did he say?
He said, I'm sorry.
Objection has to answer. No further questions.
Okay, I just need some clarity. She said he was behind the car door.
Yes.
Would it be helpful if we had the witness draw it out?
Yeah, because I just want to
Yes,
make
Your Honor,
sure
that's fine.
what she's talking about behind the
That's
car
fine.
door is what I believe behind the car door.
This will be mark it as People's Exhibit number 1, then, Your Honor. I'm just tearing off a sheet of scrap paper here, and we'll have the witness draw out exactly what she's talking about. Approach.
Yes.
Clean sheet of paper. Been marked as People's Exhibit number 1 now. Take this piece of paper, take that pen there, and I know that it's probably easier to draw than to describe. So just draw exactly what you're talking about. Start with the AutoZone.
Draw the AutoZone
Sure.
building.
Let's start with the AutoZone. Would you mind marking that as AutoZone? A new sheet of paper, or just keep going there. On the front side, just keep going. Do your best. It's
Your Honor, is there a chance we have a clipboard for the witness?
Clipboard.
And it doesn't have to be perfect. We understand you're just doing the best you can. Would that be an accurate depiction of how your car door, you and the defendant were all positioned in relation to the AutoZone when he broke?
Yes.
And at this time, I think I would move to admit People's Exhibit. We haven't formally done it yet.
I
Sure.
Approach.
Move to admit People's Exhibit number 1 at this time.
Any objection?
Same objection. Same objection as the given that the witness had previously testified, she did not know what Mr. Cole was at the time.
The objection is overruled. Goes to her credibility. Okay, just so that I am clear. Ms. Hayes,
Yes.
you need to turn to me if I'm talking to you.
Oh,
Thank you. Car door, and this stick figure is you?
yes.
Okay, and then this is the defendant?
Yes.
Thank you. Any additional questions?
For the questions, thank you.
This witness can be excused.
Thank you. Happy holidays.
It is, any additional witnesses today?
Yes, Your Honor, at this time, people would be requesting a continuance now to be able to present definitely Detective Kasha Osborne, potentially Officer Meekoff. We'll have Officer Meekoff available. He was the initial report writer on it. I don't necessarily think we need him for this case, but we'll have him available next time. Okay, we'll have him available. And we'll also work on obtaining, but we'll also work on obtaining that video evidence. And
That was my next question. Do we know how long Detective Osborne is on?
I tried to ask her. I'll start asking around to sergeants and detective sergeants. Maybe they have a little more detail. I tried to ask her directly in hopes that she would be back by now. She had initially indicated sometime in early to mid-January when I asked for a timeline. It sounds like that's looking more towards mid-January. But I will work on getting an answer for that. I think if we adjourned it out maybe a month or so, it'd give us enough time.
February 13th at 9. February 13th at 9. And you could notify us prior to that date if you've not received your discovery. That way we can push the date out in advance so that you won't have to have your client come needlessly. I'll give you the exhibit back for now.
Yes, sir.
That was exhibit A.
Exhibit 1.
Exhibit 1. Okay, let's see, continue. Set at 500 personal work progresses, and that will continue. Any additional matters for the record?
Okay, thank you. All right, man. Have a good one.
Anything else, John?
Not for today, sir.
Have a moment to just check the hall for witnesses. I believe Ms. Maycomer's here on her vertical for the Shepherd.
Do you know who this is in the jail? What's your name?
Jeremy Shepherd.
Jeremy Shepherd. Do you have an attorney? He doesn't have an attorney. Who's representing? That's yours?
It is mine, Your Honor. I believe Mr. Watson is correct.
Oh, okay, sounds good. On the record in the matter, the people of the state of Michigan versus Jeremy Shepherd, 24-03662. Appearance, please.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Your Honor, my name is Keith Watson. I'm the public defender. I'm appearing today on behalf of the Office of the Public Defender, not specifically on behalf of Mr. Shepherd, although I've made some efforts as it relates to Mr. Shepherd's case.
Okay, today was the date that was scheduled for preliminary examination. I had a note here from Judge Ward, in a class conference in my absence, indicating we would treat this as a PCC because we were awaiting conflict counsel. So it doesn't sound like we've gotten conflict counsel yet.
I have now, Your Honor, just as in another matter that was before the court today. We had some difficulty securing some roster attorneys for conflict matters. But David Carter, who has represented very recently Mr. Shepherd, has spoken with Mr. Shepherd. It's my understanding Mr. Shepherd would agree, Mr. Carter represents, if only the matter might be set on for another date. Mr. Carter is prepared to file his appearance.
Okay, so by nature of how we're appearing today, this matter was going to be set out anyways. The court will find good cause based on the record to adjourn the timeline to go beyond the 21 days and have this matter set, giving Mr. Carter time to file his appearance and get discovery. Let's see. This is not one that, an exam that would take more than an hour or so, correct?
That's correct, Your Honor.
So we'll reset that. February 13th at 9:30. February 13th at 9:30.
I'll make note of that, Your Honor. I'll pass it along to Mr. Carter right away.
Thank you very much. Bond was set at 50,000, 10%. That will continue. Any additional matters for today's record?
None particular. Okay.
Nothing from the defense. Thank you.
Thank you. You're all set for today, Mr. Shepherd.
Thank you, Your Honor.
Thank you. Wow. Somebody's phone. Is someone's phone on?
No, it's not.
Everyone, please double check your phones, make sure your ringers are off or your phone is turned on.
Thank you for being here. I know I'm probably saying your name. Van Eve or Van Buck?
It also includes Apple Watches.
Sure. Yeah. Hoya and Darren Smith.
Good. Okay. You ready on Cameron Brown?
Your Honor, I just checked the hall for the necessary witnesses on that case. I haven't seen.
On the record in the matter of the people of the state of Michigan versus Cameron Dewan Brown, 24-03688. Council appearance.
Morning, Your Honor. Case of Markarian appearing on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, who was in the courtroom 10 minutes ago. He had to go downstairs, but he is here.
Did he have braids? Who's here? Okay, I saw him walking that way. I'm not sure where he went. I did see him present today. Today was the date set for a preliminary examination. And we do not have necessary witnesses at this time.
I haven't seen them, Your Honor. I did have recent contact with them. That's why I'm a little confused. I know we had some subpoena issues over the holidays with things not going out. I didn't see this on my specific list. I'll check when I get back to the office. I assume this is one that our office might be interested in reissuing if it's dismissed, although I can't say for sure, but I did have recent contact with the victims as of a week ago and advised them of the date, the time. They said they would be here, so.
Do you have a phone number for them?
I do, and it's active.
Okay, did you want to attempt to call them today while we wait for him to return to the
Sure
court?
thing.
Okay, off the record. And then what about Jameed Davis?
I believe it's going to be a waiver, Your Honor.
On the record in the matter of the people of the state of Michigan versus Jameed Davis, 24-03659, appearance, please.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Davis, who is standing to my right.
Okay, Mr. Davis was scheduled to have a preliminary examination today. Felonious assault, yes, an assault with a dangerous weapon, and there's an unconditional waiver today.
Yes, Your Honor, it's going to be an unconditional waiver by both parties today. However, it's with an agreement to an added count of felony firearm as well. So it will be a waiver with an added count of felony firearm. Necessary witness Anthony Van Dyke did appear.
Thank you, Mr. Davis. You understand that you have the right to have a preliminary examination on the charge as it's currently pled, as well as the added count. You understand that? You have the right to require that the prosecution put forth evidence at the exam that would establish that they even have sufficient probable cause that these crimes occurred and probable cause to charge you with those crimes. You understand that? If you waive your exam, that means that there won't be any hearing establishing that they had sufficient probable cause. You understand that? You want to do that today? Anybody promising you anything if you waive your exam? Has there been any promises made to you to get you to waive your exam? Okay, and you're waiving it of your own free will? You're waiving it of your lawyer's will? I'm asking you a question, so you answer my question right now. Are you waiving it of your own free will, or are you waiving it of your lawyer's will?
Mine.
Okay, then you can sign that paper.
Sorry, Your Honor. This is like my first.
Your Honor, may I approach?
Yes, thank you. No problem. Just want to make sure you understand, because it's an unconditional waiver. Once you enter the waiver, you cannot change your mind. So that means that once I bind this matter over to the circuit court, it's done. So I need to make sure that you are waiving it freely and voluntarily, which is what the paperwork you just signed says that you did, and that no one is threatening you to do that. So I find your waiver to be unconditionally made and voluntarily given. The matter will be bound over to the circuit court. The bind over date's going to be January 15th. And that's the date that the circuit court's going to get the file from the district court. You do not need to appear in circuit court on that date. Okay, your next court date is going to be a pretrial, and then after they get the file on the 15th, they'll set that date, okay?
Okay.
And so your attorney will be made aware of that. Do you have any questions at this time?
Okay.
Justin? Okay, your bond was filed with your personal recognizance. That will continue. Is your address changed since the time that I arranged you? Any additional matters for the record?
From the people, thank you.
Your Honor, I would just put on the record that this was a plea offer made that involved the waiver of the preliminary exam. The details of that still need to be ironed out in the circuit court. We will continue negotiations at that.
That's correct, Your Honor. Negotiations will continue in circuit court.
And the added count two was for felony.
Felony firearm. Yes, sir.
We're all set for today. Thank you.
Okay, thank you, Your Honor.
You're welcome.
Yeah. I'm working on it.
Did Mr. Brown return?
Yes, he did.
Oh, okay. Did you have a chance to call? You wouldn't.
Mr. Abu. Tried this. I practiced it. Abu Malud, Mr. Abu Malud. I tried to pronounce his last name. So
Okay,
he's calling.
okay.
That's the long story short.
He has a tough name, huh? I don't know what his name is.
Abu
I don't know that I
Ghassi.
met him, actually.
Abu Ghassi, I think it is.
Oh.
I'll have to ask him.
Okay, I see Ms. Juan, she has Perry and Phillips. Yes. How are we expecting to run those?
I am unsure. This one.
Oh.
Very Phillips, yeah, I agree too, and they're calling Fox. Phillips gonna be a waiver, Your Honor.
For the record, in the matter of the people of the state of Michigan versus Chase Scruggs. That's 24-03567.
I ran to the restroom. Just don't know.
I don't know why anybody's gonna wrestle when I'm sitting on the bench.
I think it was you left.
I think it's gonna be an adjournment request, I believe. I don't know if he wants to waive his appearance for that purpose.
You want to waive his appearance as a request?
I would be fine with that, Your Honor.
Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Dustin Coons for Chase Scruggs. He's in the courthouse.
Okay, today was the date that's set for preliminary examination at the Hindu instruct. This is a home invasion first, actually, and a domestic violence. And there's a request to adjourn.
Sorry, Your Honor. Well, I guess this would also require 21-day waivers. Probably should be.
No, it's your request to adjourn.
It is.
Okay, sounds good.
Would you like me to state the reasons or should we wait?
We can wait for your client to come back. And we can bring up. Who's gonna be, you said a waiver on who?
Phillips.
We can bring up Phillips. I'm sorry?
If we're on appeal.
A waiver of what?
It's the appeal.
Trail.
Trejo is a waiver? Okay, on the record in the matter of the people of the state of Michigan versus Adam Trejo, 24-03696.
Morning, Your Honor. Randall Berman on behalf of the people.
Simon, you're a man and you want to come to the
Did Mr. Trejo appear for his PCC
He did, Your Honor.
in person?
He did. We were, the judge, because I had told that we were going to wait for the preliminary exam. I called my client, he was on his way here. He was going to appear in court.
When did he appear? See the judge?
I got I was here like 9:45 or.
Did you see the judge last week?
No, I didn't. The court officer said that they were already. I went in the courtroom.
Because he didn't appear.
It was on his way, Your Honor. The case, the judge took the case a little bit earlier than,
Your Honor, if I may, I can confirm that the judge did take the case early because I came at 9:26 for the 9:30 PCC and I was told that it had already been addressed on the record last session. So on the record either.
Before the time it's called. Nonetheless, my concern with Mr. Trejo is I have him on the 6th for another matter. I don't want him to think that being here today means you don't have to come back for your other matter. You know, you have another matter that you need to appear in court for? Okay. Today was the date that was scheduled for a preliminary examination on, this is a weapons charge of possession by prohibited person, possession by felon, and 2 counts of felony firearm. And there's a unconditional waiver, is that correct?
That's correct, Your Honor, by both parties negotiations. Approach.
Yes, Mr. Trejo, you understand you have the right to have a preliminary examination in a district court?
Yes, ma'am.
You understand the purpose is to have the prosecution establish that they have sufficient probable cause that these felonies were committed and probable cause sufficient to charge you with those felonies.
Yes, ma'am.
And you wish to unconditionally waive your examination?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Has there been any promises extended to you to get you to waive your exam?
No.
Your bind over date is January 15th. The date the circuit court will get the file from the district court. You do not have an appearance on the 15th, okay? Your next court date on this file will be a pre-trial at the circuit court. Your attorney will be made aware that you remain in contact with Ms. Wong. A bond in this matter was set at 5,000 personal recognizance with GPS tether and house arrest. That will continue in the additional matters.
yes, Your Honor. Does my client has permission to go to the hospital? He has some health issues. And I don't think that he should be around people at this time.
You don't think he should what?
I don't think that he should really be around people at this time because he has an infection.
He's gonna be hospitalized?
We want him to go to the hospital, Your Honor.
The bond allowed for him to report to court or medical, so.
I just wanted to make sure.
Yeah, you have to be at the hospital or you gotta be at court.
I just wanted to make sure I didn't want to just go on my own. I understood that part. I just wanted to-
Oh, yeah, you typically, if you're sick, you gotta go on your own. That's up to you to get yourself there or an ambulance, so we wouldn't have any control over that. But we do have ability to verify that you're there.
Yeah.
And so that order will continue. Any additional matters on this file?
Just to confirm, he's due back here on the 6th for a separate matter.
You are due back here on the 6th for a separate matter. You understand that?
Yes, ma'am. At what time?
1:30.
Thank you.
Thank you. Any additional matters?
No, Your Honor.
No,
Thank
you're
you.
not.
Thank you. You're all set.
Thank you. Have a good day.
Same to you. Okay. On the record in the matter of the people of the state of Michigan versus Chase Scruggs, 24-03567. Here, please.
Morning, Your Honor. Page Mark Aaron, appearing on behalf of the people. Good morning again, Your Honor. Dustin Coons for Chase Scruggs, who's now here to my right.
Mr. Scruggs has a home invasion person and domestic violence exam for today. And we're requesting an adjournment.
That's right, Your Honor. The purposes for the adjournment would be, there is a fair amount of history between my client and the complaining witness here. I am trying to put together, try and gather that information, put together something for the prosecutor so we can work towards a resolution on this case. Asking for a little bit more time to do that. For what it's worth, I don't know if the people's witnesses are here today, but we're not requesting dismissal. I don't know. I haven't seen this. No, Your Honor. Olivia Shook has not appeared yet today, but to be fair, that was one of the ones that was specifically listed on the subpoenas that did not go out over the holidays that I got. So I think it's just because she didn't understand. Our office has had contact with her.
Sounds like there's a stipulation to adjourn.
Yes, Your Honor. I have no objection to it. I'd be willing to stipulate. It's fine.
Okay, Mr. Scruggs, you have the right to have a preliminary examination within 21 days of the date that you were arraigned. Did you know that? Okay, so you were arraigned on the 17th. Did you want to waive your timeline to have this reset?
Just the waiting.
Did you misunderstand my question? So when I asked you a question, why did you look over there and ask him? If you misunderstand, you ask me to rephrase it, but I'm talking to you now. So because I need to understand that this is your will. You want to waive the timeline so I can set this to a new date? No one's forcing you to do that? No threats being made or promises to get you to go beyond the 21-day time? Okay. What's your new date? February 21st at 8:30. Does that date work for you, counsel?
Yes.
Well, we know it works for you.
It doesn't stick out. So I will be here.
February 21st. 21st. What time? At 8:30. Okay, well, we set it for that date. We'll get your new notice to appear. Any additional matters for the record?
New people. Just to be clear on it, that's that's the preliminary examination.
That's correct.
Okay.
It's another preliminary, it's a preliminary examination date, and bond was set at 10,000 personal recognizance. There's a no contact order that will continue. And we're all set. Thank you.
Was able to make contact with one of the victims of the Cameron Brown matter, Your Honor.
Okay, all that matter. Back on the record in the matter of the state of Michigan versus Cameron Brown, 24-03688. And we went off the record to allow the prosecution to try to contact witnesses, and because Mr. Brown was not present in the courtroom. You had an update.
Yes, Your Honor, I did speak with LaToya Smith on this matter. So the phone number that I have, it seems to be a shared one between these two. It's brother and sister. Last time I called it, it was Daryl Smith, one of the victims. This time it was LaToya Smith. So I can now say I have spoken to both of them. They are both interested in continuing this prosecution. They are both willing to show up to court. It sounds like they didn't get subpoenas. I can't confirm that for sure, but I know we had some holiday subpoena issues. So that is my assumption as to why they are not here today, as I believe I woke LaToya Smith up. However, she did make very clear she would be willing to participate at another hearing at another date when she has her subpoena, as she just believes she didn't get it. So I would request an adjournment at this point based on that contract. I certainly understand if Your Honor dismisses if this is one we would be looking into reissuing, and I've advised LaToya Smith of both the possibility of a dismissal and a reissuing as well.
Mr. Freeman.
Good morning, Your Honor. I understand the comments offered by counsel. Nevertheless, on behalf of my client, who scheduled to go forward at 9 o'clock this morning, it is well past, and I respectfully on his behalf move to court for dismissal without prejudice.
File a motion to dismiss is denied because they've indicated they're just going to reissue the charge, which means you have to come back and be rearranged. And so that's an unnecessary use of resources. So the court's going to find good cause to go beyond the 21 days to allow them to properly subpoena the alleged victims to appear at this new date and time. February 21st at 9:30. February 21st at 9:30 is the new date. We'll get you a notice to appear. There's a bond that's set at 7,500, 10% with a no contact order in place for the protection of Daryl and LaToya Smith. You're not to be within 2,000 feet of wherever they live, work, or go to school. Do you understand that, sir?
Yes.
Okay, we'll get you a notice to appear. Any additional matters for the record?
Nothing further from these people.
Nor from the defense, Your Honor. Thank you.
Thank you. You're all set. Is that Mr. Phillips?
Yes.
On the record in the matter, the people of the state of Michigan versus Donald Ray Phillips, 23-03148. Appearance, please.
Good morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Mr. Phillips.
Okay, today was the date that was set for a preliminary examination. This is for controlled substance possession of methamphetamine. How are we proceeding on this?
It's going to be a waiver from the defense, and I believe that there's also going to unconditionally waive the preliminary exam.
People would also unconditionally waive their right to an exam.
Okay.
Yeah, for sure.
Yes. Mr. Phillips, do you understand that you have the right to have a preliminary examination here in the district court?
I do.
You understand the purpose of the exam?
I do.
So you have the right for the prosecution to have to put forth evidence that will establish that they have probable cause sufficient that these felony or the felony occurred, and then sufficient probable cause to charge you with the alleged felony. Do you understand that? You want to give up your exam? Is anyone threatening you to do that? Has there been any promises extended to you if you waive your exam?
Yes,
You're not sure?
I guess not.
You're not sure?
Well, I don't know if it's a promise, we agreement, I guess.
Well, I don't have any agreements and agreements.
Well, no, it's a promise.
You're expecting a plea offer, is that what you're saying?
Something like that.
Was there an offer on this?
If I could clarify, Your Honor, the offer essentially was to not increase this to a habitual fourth offender as it should have been charged. It was only charged as habitual second offense of notice. So I think the actual offer we gave was to plead with no half. And if he ran the exam, then we would be changing it to a habitual fourth offense.
That's right.
Okay, this was charged as a half second. So that was what enticed you to want to not run your exam, sir?
Yes.
Okay. No other promises though, or threats? Okay. Your bind over date's gonna be January 15th. That's the date the circuit court gets the file from the district court, not a date that you have to appear in court, okay?
Yes.
Have any questions? I'm asking
No,
you, do
I'm
you have any
sorry. No,
questions?
no
Okay, okay. Your next court date will be a pre-trial. Your attorney will be made aware of your next court date at the circuit court. A bond in this matter was denied. Any additional matters for today's record?
Nothing from the people.
Yes, Your Honor, I would like to address one. My client reported to me that he is in need of some sort of treatment, inpatient treatment. And at this time, there is a hold from the parole for the parole office, from the parole people. And we would like to work with the parole officer in order to get him into treatment. However, the fact that there is no ban on this case is going to be an impediment. We have to wait until the case is bound over. So if the case is at a quick trial date, so we would like the court to set a bond in an amount that my client can pay. At this time, I don't think that this case is one of those cases where a bond is not required.
This is one of those cases where he was supposed to be here in February of 2024. It's January 2025. He never showed up. Bond's denied. He can take up his bond request at circuit court.
Nothing further from the people. Thank you.
And what are we doing with Perry?
I think I would just need to check to see if Officer Fox is here.
You can bring Perry up.
And Albert Taylor, I know we're ready. I haven't seen the necessary witnesses on that. I'm not proceeding victims either.
On the record, in the matter of the people of the state of Michigan versus Albert Taylor, 34-01773. Appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Morning, Your Honor. Jacob Thorne on behalf of Albert Taylor. And my right.
Okay, Mr. Taylor was scheduled for a preliminary examination with an assault with intent to do great bodily harm, less than murder, and a domestic violence third. He said the necessary witness is not.
Yes, Your Honor. The necessary witness, Letitia Robert Hicks, has failed to appear at this time. We have sent her a subpoena. In fact, even up to this morning, our victim advocate at our office did make contact with her. To be clear, since this case has been pending, her mind has not changed. She does not want charges pressed. She doesn't plan to show up to court. So that's why I really don't see any point in running this victim.
Counsel.
Make a motion to dismiss.
Motion is granted without prejudice. The case could be reissued against you if the victim changes their mind and the people are ready to proceed. You understand that? If that happens, then you would have to be rearranged. But we'll get you a copy of dismissal in just a moment. Have we seen Diamond Wiggins? No? Not good. I'm sorry? What's your name? Why are you here for her? Okay. You're a sister? Okay. I think I did have a note here. She was in the hospital. Do you know how long she'll be in the hospital?
It's bad.
You don't know how long? Who's representing her? Is that you?
Where would the case, what,
No, who's representing Ms. Williams? This is set for sentencing.
Jacob Raleigh.
Mr. Raleigh,
Your Honor.
thank you. Lisa Swain did not appear. No.
I don't know if Emily had just scheduled that. I don't know if she received it. And stuff, honestly.
Yeah, I only saw this for show cause on the 26th.
Yeah, so.
Let me just go see who's here. So. Hope it says. Yeah, there's no reason problem.
On the record, in the matter of the people of the state of Michigan versus Marquise Washington, 24-03116, appearance please.
Good morning, Your Honor. Case Mark Herring, appearing on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Washington, who is standing to my right.
Mr. Washington sure did rack up some charges here, huh? CCW, weapons, firearms, possession by prohibited persons, weapons, possession by prohibited persons, felony firearm, police officer resisting, obstructing, FST, personal injury accident, lying to a peace officer in an OWI. How are we proceeding today?
Your Honor, if the court recalls, we did start this exam back in, I think it was November. At that point, I called Officer Saliba Moshi and Officer Kyle Mikolajczyk. I did present some proof for a firearm that was recovered, a vehicle.
I can't hear.
Firearm that was recovered, a vehicle it was recovered from. I provided Your Honor proof. I still have with exhibit number 1 of a previous qualifying conviction. However, at this point, I don't know what to say other than I don't have officers here. We have tried to call them. I have attempted to call them myself. I have had other officers attempt to call them. I keep getting told that Officer Malik is on his way. He's the named victim for the R&O charge, and I haven't seen him. I have no reason to believe he's not on his way, but the bigger issue is I don't have Officer Seth Osentoski here.
Okay.
Seth Osentoski is one of the most necessary witnesses to this case, especially when it comes to proving any of the felonies. I have been advised by officers that it sounds like Officer Osentoski doesn't plan to show up. I didn't know that was an option, but it sounds like that's where we're at. I'll discuss with my bosses afterwards if Your Honor wants to do it as dismissal. I'll discuss with my bosses afterwards to figure out how to do this and how to proceed going forward.
Let me just get some clarity. Officer Malik is not here. He was not present on the 1st. And you're being told he's on his way, but he's not here yet, and he was supposed to be here at what time?
I believe this was set for 9 a.m., Your Honor. It's now
It was definitely
10:55.
set for 9 a.m., so 2 hours late, and there's no officers. And then Officer Osentoski, who still works for.
Still works for the Lansing Police Department. I believe plans to continue working for them. Sounds like doesn't plan to show up for this subpoena at least, or maybe other ones. I'm not sure. What I was more or less told is that he's asleep and he's not going to be coming to court.
Counsel.
Your Honor, at this time, I would ask that all the felony matters in this case be dismissed. There are misdemeanor matters which obviously would not require a preliminary exam, so the court could continue with those. We would ask that felony matters all be dismissed.
motion to dismiss is granted, for all the felonies will be dismissed. I'm trying to find out where my- It's notes about this. Yeah, I can just start it then. And so they're dismissed without prejudice. That means that the prosecution does have the right to reissue the felonies against you. Do you understand that?
Yes, ma'am.
Okay, we'll get you a dismissal as to the felonies. The other matters will convert for a pretrial date, okay? January 13th at 10:30. Let's see, January 13th. At what time? 10:30. 10:30 for the pretrial. And the pretrials will be as to the OWI. Line to peace officer. To stop at property damage accidents. And we'll get you a notice for the dismissal on the felon, okay? Do you have any questions?
Your Honor, we do have one matter. He is currently on tether. Now with the fact that the felonies have all been dismissed in this matter, would the court consider removing the tether as a bond condition? And
Tether is removed.
you also had an issue with curfew? Okay, it's a curfew. Okay, tether. So that's just.
Let's see here, he had a GPS tether curfew 7 p.m. to 7 a.m. Be at your home. Provided a Florida address. And told him he could not go there while cases pending. You live in Florida, sir?
Yes, ma'am.
How long have you lived in Florida?
Like 2 years.
Oh, so you were up, you have family here or something?
Yeah, I was down here visiting.
Okay.
It was a funeral going on.
Got it, okay. So that you have no WI. Police officer. There is stuff at property. Tyler. I'm inclined to believe, because there's no WI on this, is there gonna be a request for him to get a screening done before an offer could be extended on that?
I think it would be appropriate, Your Honor. I don't know if he's interested in taking any offers. Obviously, I can't speak to that. I think it would be appropriate to do screening.
Well, I'm just trying to figure out the, how I should set this, just because I'm not inclined to make him stay in Michigan for misdemeanors. He can appear via Zoom. He doesn't live here.
Your Honor, this also would be an Ingham County case, which I know the city of Lansing always has a requirement that you get the.
Correct.
Done. I don't know if Ingham County has the same mandatory.
I don't know that they do or not. That's why I'm asking.
It's not mandatory, Your Honor. If we were going to proceed with the sobriety court route, then it would be. I frankly haven't even come up with an offer on the misdemeanors yet, just because I got made aware of my officer's failures to appear moments ago. So I'm going to try to figure this out.
What is your address in Florida, sir?
4307 Newgate,
Is it 4307 what?
Newgate, Ave.
You work in Florida?
Where I did.
No.
I'm not no more.
Oh, okay.
I've been out here for at least 3 months.
Okay. And it's your intention to return to Florida?
Yeah, I can.
You can, I'm not gonna hold you here for misdemeanors. You can appear via Zoom for all your court dates. You just have to have video. Okay,
Okay. Yes, ma'am.
Your Honor, assuming our office decides to proceed with reissuing the felony charges, would that change with that, or you can't say?
if he's reissued while he's still in Michigan, I suppose, I mean. Wouldn't have been an issue if the officers thought it important enough to appear to court today. So I'm making it on so you can have your tether removed. You have to go back down to Ingham County to have the tether removed, okay?
So the jail?
Yeah, where they put it on, they have to remove it. You can't remove it yourself.
Okay.
Okay, so you go back down there, they'll remove that, and we'll send notification that that could be removed. And give me your Florida address again,
It's 4307 Newgate Ave,
spell that.
NEWGAT. 3719.
What city?
Holiday. It was Newport Richie Holiday, the same thing.
Okay, sounds good. Any additional matters for today's record?
No, Your Honor. Thank you.
You're all set.
I think we can go on the record for Perry at least, Your Honor.
On the record in the matter of the people of the state of Michigan versus Sean Perry, 24-01296.
Morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Good morning, Your Honor. When I get the warrant for Mr. Sean Perry, who's by my side at the council table.
Okay, this is a preliminary examination for stolen property receiving from stolen motor vehicle. And are we running an exam today?
Your Honor, I've been advised, Officer Mark Fox was on this case. He's a night shift officer. I think he woke up late, but I do actually have communication from him directly advising that at about 10:48 a.m. he left his home to get here. He said it would take him about 40 minutes to get here, so that puts us around 11:30. He should be here around that time and ready to go. I certainly understand that this was set for much earlier than that. He should have been here on time.
You said he'll be here around what time?
Looks like about 11:30. He said 40 minutes from 10:48 a.m. So approximately 11:30. So we should be here soon if we want to wait for him, but I know that they had entertained the possibility of a waiver. The offer on this case was to plead as charged with consent to HYT status.
And I'm gonna make it wait.
You're gonna waive the exam? Okay, you understand the purpose of the exam? So you have the right to require that the prosecution establish that they even have probable cause sufficient, that a felony was committed and then sufficient probable cause to charge you as the person who committed it. You understand that? Ms. Wanji, can you grab this, please? Anyone threatening you to waive your exam? Any promises if you waive your exam? Find your waiver to be freely and voluntarily given. The matter will be bound over to the circuit court. Find over date January 15th. So that's the date the circuit court is going to receive the file from the district court, not a date that you have to appear in circuit court, okay? Your next court date will be a pretrial. Your attorney will be made aware of that date, and you will maintain communication with your attorney. Let's see. I don't know that we have a accurate address for you. You have a home address? Okay, whose address did you provide at the time of your arraignment on December 17th?
I believe it was 3519.
No, that's not the address that you provided.
Oh, I'm sorry, 49.
Whose address is that? That, the one that you just gave me?
First, that's the one with my dad.
Or your father lives here?
No, he lives in Grand Rapids.
Okay, why did you provide us an Okemos address? Ms. Wanji, I'm talking to him. I need him to
Yeah,
answer.
that's the one that's cited that I'm saying.
Whose address is it? Okay. And your father lives in Grand Rapids? But you're from New York. Was remanded after failure to appear since May 2024. No bond will be issued. Any additional matter for the record?
Some people think it.
Can I respond, even though you're the.
You can.
Thank you. My client has an address here in Ingham County, like the address that he provided before. We do believe that this case, so my client would like to have it better. He's willing to abide by all the other conditions of the bond. And if that will allow the court to know all the time where he's at. And this is just a case. I don't believe that. I understand that he failed to appear in May, but again, this is not one of those cases where no bond is warranted.
The defendant was arraigned by this court, a magistrate number back on April 30th, 2024, did not at the time provide a valid address. The magistrate advised that he needed to provide an address within 24 hours of release, granted him a personal recognizance bond. Was told that he needed to appear for a probable cause conference on May 10th at 9 a.m. Defendant failed to appear in court on May 10th. Defendant was told that he had a preliminary examination on May 17th, 2024. Defendant failed to appear on May 17th for a preliminary examination. He turned himself in on this warrant. Exactly. So he had no intention of appearing in court on his own recognizance. He doesn't even have a valid address here. He just went back and forth as to whose address this was he gave back in December 17th. His father lives in Grand Rapids, and then he told the magistrate on the 17th that he didn't come to court because he had no transportation, he had no way to get there. So we don't trust that he'll have transportation or a way to get here. So I think it's best that he stay remanded so that we can make sure this gets resolved in a timely manner, hopefully in 2025. Any additional matters for the record?
Nothing from the people.
Nothing for the defense.
You're all set. And so we just have two in the afternoon.